Atilano v. Chua, Ching Beng, GR number L11086, March 29, 1958. Summary. Wife Pilar Atilano had difficulty with her in-laws when she and her husband Chua, Ching Beng visited her family in Zamboanga City. She related this difficulty with her parents. Her parents convinced the husband to return first to Manila, and that the wife would just follow him later. However, Pilar did not return to Manila. Instead, she filed a complaint for support and alimony pendente lite against her husband, alleging that they had been estranged and living separately since October 1952. CFI Zamboanga granted the petition. Chua filed a petition praying that he be allowed to fulfill his obligation by receiving and maintaining in his house, apart from the house of his parents, the wife who has a right to receive support in pursuant to Article 299 of the Civil Code. This was denied by the CFI, but the Supreme Court granted this option, and even ruled that if the wife did not choose to live with her husband has no more obligation to give any support to the wife. Opponent D. Justice Felix. Facts. Chua, Ching Beng and Pilar Atilano were married in Zamboanga City on May of 1951. The couple established their residence with the parents of the husband. When the couple visited wife's family in Zamboanga City, her parents convinced the husband to return first to Manila, and wife would just follow him later. However, Pilar did not return to Manila. Instead, she filed a complaint for support and alimony pendente lite against her husband by reason of incessant marital bickerings and quarrels brought about by incompatibility of temperament and, above all, by defendant's inability to provide for themselves a home separate from the latter's parents. The wife's refusal to return to Manila was caused by her aversion to stay with the parents of her husband after she had experienced some previous in-law troubles. Defendant husband contended that, 1. Their married life was characterized by harmony and understanding. 2. Plaintiff's parents caused her to be alienated from him, resulting in her refusal to return to Manila and live with her husband again. 3. That defendant went back to Zamboanga City to fetch her, but through force and intimidation she was prevented by her parents from going with him. And 4. That her parents exerted undue pressure and influence upon his wife to file the complaint. Defendant further averred that while he was not evading his obligation to support his wife, he preferred to fulfill said duty by receiving and maintaining her in Manila, that as the husband, defendant had the right to fix the residence of his family, and he would even be willing to establish a conjugal dwelling in Manila separate from that of his parents if that was the plaintiff's desire. CFI Zamboanga rendered judgment granting the wife a monthly allowance of 75 pesos. Defendant filed a petition electing to fulfill his obligation as thus fixed by the trial court by receiving and maintaining plaintiff at his residence at Pas City, which was apart from that of his parents, with the prayer that in the event, plaintiff would refuse to receive support under that setup, that he be declared under no compulsion to remit the allowance to her at Zamboanga City. This was denied by the CFI, hence this petition filed before the Supreme Court. Issue: whether or not a wife is entitled to received support from his husband where she refused to live with him on account of some misunderstanding she had with the husband's immediate relatives. Held, no. Article 299 of the Civil Code provides, quote, "The person obliged to give support may, at his option, fulfill his obligation either by paying the allowance fixed, or by receiving and maintaining in his house the person who has a right to receive support. The latter alternative cannot be availed of. In this case there is a moral or legal obstacle thereto." End quote. Husband in this case is given the option to fulfill the said duty either by paying the allowance as fixed by the court or receiving and maintaining the person entitled thereto in his house. In giving the obligor the option to fulfill his duty, it provides for only one occasion when the second alternative could not be availed of, that is, when there is a moral or legal obstacle thereto. While physical ill-treatment may be ground to compel a husband to provide a separate maintenance for his wife as held in the case Arroyo v. Vasquez do Arroyo, said allegation was not proved during the trial. Instead, the lower court found that the root cause of all their differences could be traced to disagreements common among relatives by affinity. That misunderstanding with in-laws, who may be considered third parties to the marriage, is not the moral nor legal obstacle that the lawmakers contemplated in the drafting of said provision. Decision: the decision appealed from CFI is hereby modified by giving the defendant husband Chua, Ching Beng the option of supporting his wife at their conjugal dwelling apart from the home of the parents of their husband. Should plaintiff wife refuse to abide by the terms of this decision, then the defendant appellant Chua shall be considered relieved from the obligation of giving any support to his wife.